For rights and obligations also, this is an intro that you can give, that mutual relations between partners of a firm come into existence through an agreement between the said partners. Only when we have agreed on it, after that only it would be binding. Like under contract act, there is a provision, right? Consensus ad idem. Consent makes it law. Only when you have consented, it can be binding on you, otherwise not. So same thing applies here also, that mutual relation between partners of a firm would come into existence only when they have agreed on that by way of an agreement, right? This gives rise to mutual rights and duties to every partner who are involved in that specific business. And we have sections 9 to sections 17 of Partnership Act that lays down certain provisions with regard to mutual relations between partners, and these relations are governed by existing contract among them, which may be implied or expressed when they are dealing with it. Every agreement may vary depending on consent of all the partners. Now, even though we have all these different rights and obligations, right? More than all these rights and obligations, what have they agreed in that specific contract, right? That would also matter a lot. So whatever they have agreed, whatever they have consented to, that also would be taken into consideration, and accordingly they would be made liable, agreed in their agreement. So these are 14 different types of rights that we have, and some about 7 different types of obligations that are there, right? But again, sections, if you feel this becoming complicated, you can skip remembering the sections. If you feel you can remember, then you can go ahead and remember the sections as well, right? So these kind of some intro you can give. You can also mention with regard to that consent thing, right? That you cannot be held liable unless and until you agreed on something. Like there should be free consent, right? You unless and until you have consented, you are not liable. So we have this provision. It says consent makes the law. Unless and until we have agreed on something, we are not bound by it. This also you can mention. So that same provision would apply here as well. So these are the 14 different types of rights and obligations that we have. So these are the rights, okay? First one is right to take part in conduct of the business. Now in a partnership, why are these partners coming together, signing an agreement and getting themselves registered and all that stuff? It is only for doing some kind of a business which would be profitable for all of them, right? So accordingly, they will have a right to take part in the business as well. All the partners would be having a right that they can take part in the business. They can also give their opinions. They can also make use of their skills, knowledge, whatever they are having, right? So that is a right which is given to partners. Now, wrongfully, if all the partners come together and they decide that we are excluding this one partner, they are not allowing one of the partners to take part in the business, right? They are not allowing that partner to give his point of view or might be make use of his skills or anything like that, basically excluding him in terms of conduct of business. In such a case, that person can go to court and file a case with regard to it. What kind of relief he may take? It might be with injunction. He may ask the court to pass an injunction order. So what is injunction, you remember?
Injunction means stopping someone from doing something, like preventing a preventive order, like.
Yeah. So injunction basically is court will order, right? It may be that you stop doing something, like you stop excluding this other partner from taking part in business, or might be court would ask them that you involve this partner in your decision making meetings or whatever it is, right? Injunction might be in both ways. You either do something or you stop doing something. So that person can go to court and ask for an order for injunction that these partners must stop excluding that person from taking part in the business. That kind of relief also he may seek. Other reliefs that are available are sued for dissolution a suit for accounts without seeking its dissolution, so on, for the partner who has been wrongfully deprived of. He might say that these partners are not working for mutual benefit, or they are not working for profit of the organization and other stuff, so these organizations should be dissolved. With regard to dissolution also, he may say, or he may say that I do not want to continue being a partner in this organization or in this partnership, so you need to separate my accounts. Whatever I get from you, you give that. Whatever you get from me, you get the things clear. And after that, like, I'm not asking for dissolution, but rather you make me free. I want to just come aside, right? Those kind of orders also that person may seek. So ideally, he is having a right that that person also should be involved in the conduct of business, because all the partners are same, right? No one is inferior, no one is superior. So person is having a right that he or she also should be entitled to take part in the business and also have a say with regard to all the matters that are going on. So it is very common to find term in partnership agreement that gives only a limited power of management to a specific partner, or a term that the control of partnership will remain vested with one or more partners to the exclusion of others. In such a case, court would generally, in the agreement, right, whenever a partner is going before court and asking for any sort of relief, court would always look into the agreement that exists between them. If there was already a provision that even if one or two of the partners want to go out from the partnership, partnership can still exist with the remaining partners. If there is such kind of a relief, then in such a case, court may not dissolve the partnership, but rather like pass an injunction order, or maybe get the accounts clear and release one of the partners, right? Whatever profit he had to get, he would get it, and accordingly it would be done. So with regard to this right, you can simply remember that right to take part in conduct of business, that's a right. If that is not happening, that person can go before court, ask for injunction, dissolution of partnership, or with regard to suit for accounts, right? Whatever is relevant, based on that, court would decide, and accordingly that specific relief would be given to the person, right? So this is right to take part in conduct of business. Next one is right to be consulted. When a difference of any sort arises between partners of the firm with regard to the business, it shall be decided by views of majority. Now, there may be like 5 partners in a partnership, right? So it's always not possible that all the 5 partners would agree to same thing only, right? There might be small things where they need to take a decision, right? Might be there is one partnership who are into some kind of a service that they are providing, okay? Might be with regard to tourism, right? They are providing guides and other stuff. Now they may feel that, okay, fine, all these Google ad and all these ads that we have, right, platforms that we have, those would help us gain customers, right? So might be there are like 3 partners who feels that maybe investing on ads is a profitable option, we need to do it. But 2 of the partners feel that no, that would be too costly for our organization. So in such cases, it's not possible for every single thing all the 5 partners would come together, all the 5 partners would have same opinion. Sometimes they would also go with the opinion of majority. If 3 persons are saying that maybe investing on ads is a good option, 2 are disagreeing with regard to it, might be they can come to a settlement, right? They may say that, okay, fine, let's try it for 3 days. We are not trying it for 1 month or so. Like that, they will have to decide in normal day-to-day things. How they will decide it, they would go with regard to opinion of majority. But that is what right to be consulted is, right? Like your opinion also should be taken into consideration. You also should be consulted when partnership is taking any sort of decision, right? So in general, it is like majority opinion would prevail, but in case they want to make some major changes, right? Might be what is the business that they are into. Might be they were into tourism business, but now they feel that it's not working anymore because of COVID and all that stuff. So they want to shift to something else, like completely different area, right? So in such cases, what happens is they cannot go with regard to opinion of majority, but rather all of the partners should agree to it, right? All of the partners should agree to it, and accordingly with that decision they would go, right? So this is nothing but right to be consulted. In general also, you would see there might be organizations where there are like 2-3 owners or other stuff. One may be of some opinion, another one might be of a different opinion. Like one person may say that, okay, because of this ongoing pandemic, might be we should declare work from home for another 1 year. Another one may say that no, maybe we should be waiting, and then we can, like gradually take a decision. Might be for 3 months we can declare. Those kind of conflict of opinion would be there. In such cases, they would go with regard to majority opinion. But if they want to completely shift to something else, their opinion of all the members would be needed, right? Simply they cannot go with regard to opinion of majority. So this is nothing but right to be consulted, right? Obviously, if it's like everyone is equal, then definitely everyone's opinion should also be taken, right? So this is right to take part in conduct of business. Whatever day-to-day activities are there, they will have the right to take part in it, and here right to be consulted. If they want to take some decision or some actions with regard to it, they also should be consulted. Their opinions also must be taken by the other partners. Next is right of access to books. So every partner of a firm, regardless of being active or sleeping partner or whatever other types of partners they are entitled to access any books of the partnership firm. There would be different records of it, right? Regarding profits, investment, capital, all those would be there. So all the partners will be entitled to access all those books, records, and everything. Partners have a right to inspect and take copy of the same if required, because it's like their own business also, right? They may be needing those information. They want some copies, they can take that also, but only thing is that it should be in good faith, right? They should not misuse all those accounts or all those stuff that they are taking, right? But it should be for like in good faith they should take. They should not misuse all these reports or accounts or whatever other stuff is being maintained by the partnership. This is clear, right?
Yes, ma'am.
So right to remuneration. No partner of a firm is entitled to receive remuneration along with his share of profits of the business by the firm as a result of taking part in the business, although this rule may vary with regard to express agreement. So in the agreement itself, right, they may share, like we have these two different provisions, right to remuneration as well as right to share profits. Now it would completely depend on whatever terms or conditions are being mentioned in it. Okay, take for example, there may be one partnership where there are like two people jointly, they are working on some business, and they have said that whatever profit we are getting, right, we are going to deposit it in the might be account, right, in the account of our partnership account, and we are going to take some remuneration, right? We are going to take monthly salary just like the other employees we are having, right? So they may accordingly decide it. Or take for example, in one partnership there are like 3 partners. One is active partner, 2 are sleeping partners, right? So in such a case, this active partner may say that because I'm investing my time and it's like my job also, I should be getting remuneration apart from profit, right? Apart from profit, I also should be getting remuneration, right? So accordingly, based on the agreement that is there between parties, it would be decided. Mostly what happens is they can also ask for remuneration over and above the share of profit that the person would be getting in terms of it. So this would be similar like other employees. They can also take salary or other commission, bonus, or other stuff. Then share of profits. Partners would also be entitled to share all the profits that is earned by the business equally. Similarly, whenever there is loss in terms of the partnership firm, it also should be accordingly, they should contribute with regard to that also. The amount of a partner's share must be ascertained by inquiring whether there is an agreement in that behalf among the partners. If no agreement is there, it can be presumed that the share of profit is equal, and burden of proving that share is unequal would lie on one person. If one person is saying that I had contributed like 70% of the capital, so I should be getting more profit. In such a case, when the person is claiming for it, right, that person should be in a position to prove that in court of law also. So otherwise, if like agreement is silent with regard to share of profit, court would assume that it will be equally distributed amongst partners. But if you want to make a separate provision depending on how much of capital is being contributed by each of the partners, that should be specifically mentioned in the agreement itself, right? So right to remuneration, right to share of profit. Then we have another one, interest on capital. So whatever amount that person had put in the partnership business, on that money, the person would get interest or not. If a partner subscribes, interest on capital is payable to the partner under partnership deed, then the interest will be payable out of the profit which they have earned as a partnership business. In a general rule, the interest on a capital subscribes the partner is not permitted unless there is an agreement with regard to it, because whatever profit you are earning, you are accordingly equally distributing it, right? And interest on capital, otherwise it would not be considered, because it is not like you are investing your money in that, right? It is like you have it's like capital you have given, right? And you are already sharing the profits. So with regard to interest also, if there is any such provision that partners want to make, it needs to be specifically mentioned in the agreement that this person has contributed a bigger amount of capital, so we are accordingly giving, like interest on capital also, apart from sharing profits, right? Might be they would say this much of interest we are paying for all the partners. After that, whatever is left, that is our profit, and then we would equally distribute it, right? So those kind of provisions also might be there. Like if there is one person who has contributed, might be 70%, 90% and 20% and 10%. If profit is equally distributed amongst all of them, that means this person is losing, right? So he may say that you need to pay interest on capital also, whatever is the percentage, and after that, whatever is left, that needs to be distributed like a profit. So even if it is equally distributed, profited, this person is gaining something more, right, with regard to interest. So that needs to be specifically mentioned in the agreement itself. Only in such a case it would be considered, right? So right to take part in business, right to be consulted, right to access books or accounts or whatever other stuff is maintained in bona fide interest, right to remunerations, share profit, interest on capital. Then we have interest on advances. Now, interest on capital. What is capital basically?
Capital is
that investment,
investment.
initial money put in
Initial,
the business.
yeah. So capital is like initial money, right? Now, once they have started the business with capital and everything contributed by partners and all that stuff, at a later stage also, right, when they are slightly growing, that time also they may feel that we need to put more money in it, right? At that time, some of the partners may give some advances, right? So advances as in at a later stage, someone has contributed some money and interest on that, right? These two are similar only. This is interest on capital. This is interest on advances that partner has contributed. If a partner makes an advance to the partnership firm in addition to amount of capital to be contributed by him, the partner is entitled to claim interest on that particular amount that he has contributed, while interest on capital amount ceases to run on dissolution Interest on advances keep running even after dissolution and up to date of payment. Like until and unless all the accounts are clear, everything is paid off, right? Till that point of time, this person would be getting this interest on advances, right? Even though the partnership has dissolved, they are no more earning profits, they are no more into business, even then this person should be getting interest with regard to advances, because that is like an investment that he has made, right, at a later stage. Like other partners have not made it, so he should be getting interest even though the partnership has dissolved and it is might be taking few months of time to get the accounts clear. That person can claim interest. But with regard to capital, it should be specifically mentioned that whether it's only profit that they are sharing or they are also entitled to interest on capital. That should be mentioned. Then right to be indemnified. All the partners of the firm have a right to be repaid by the firm in respect of payment made and liabilities incurred by him in ordinary or proper conduct of business. This also includes performance of an act of emergency that like a normal person would do for protecting the firm with regard to any loss or other stuff, right? So right to be indemnified. Now take for example, there is like one partnership where there are like 3 partners, and one day there is some, you know, like maybe fire breakout or something. They had to call the fire brigade and everything got done. Like one partner only got everything fixed. Okay, it led to a lot of you know, like expenses from his end. What he did is whatever a normal person would do in case of an emergency to protect the firm from the loss, right? Might be other 2 partners were not available during that time, or might be they were not available for next 2-3 months also. So this one partner only contributed everything. He only got everything fixed. In such a case, that partner will also have a right to be indemnified, right? Like this contract of indemnity, whatever investment he has done, that person would get it in return from the profit or savings of the partnership firm again, because that contribution he had made himself, right? So whatever a prudent man would do in such a case, just in order to avoid such a situation, like such kind of a similar situation, for that person will be getting money. These are clear, right?
Madam, can you repeat right to indemnify once again?
So contract of indemnity, do you remember?
Yes.
It's like, what have I written? It's like undo the loss, right? So in case, take for example, something goes wrong, I am there to repay. If there is one person who has bought like an LIC, some Jeevan Anand policy or whatever policy he has bought, LIC will say that after your death, your family is going to suffer some loss. So we are going to pay them just to minimize the loss that they have suffered, right? Just to undo the loss to some extent that they have suffered. That is basically indemnity. You are undoing the loss that a person has suffered. Take for example, there is a partnership firm and there are like 3 different partners, A, B, and C. Might be A was the only partner who was available in that city for a certain duration. B and C were not available for 2 months in the city. And there was some fire breakout or something happened. As a result, A had to put in a lot of money to get everything, you know, like fixed and to bring it into function, right? He had to invest a lot of money to fix everything. Why was he doing everything? Because other 2 partners were not available. Now, A has contributed his money in terms of the partnership business, right? So what happens is he needs to be indemnified. Whatever loss he suffered in terms of money, whatever loss A had to suffer to repair everything, fix everything, he will have a right to ask for its like return, right? Like reimbursement he would have, right? That undo the loss, whatever monetary loss I have suffered for fixing the loss, partnership will have to get it done, right? Partnership will have to return that money. That is nothing but right to be indemnified, that I have put in my money to fix the partnership. So now from the profit of the partnership, you repay the amount because I have suffered some amount of loss. Is it clear, or you want some other example?
Yeah. Understood.
So right to be indemnified, we have interest on advances, right to stop the admission of a new partner. All the partners of the partnership firm has a right to prevent introduction of a new partner in the firm without consent. Like I told you, right, this one, right to be consulted, right? In general, for normal things, majority's opinion would be taken, like whether to promote our services with Google ads or not, majority's opinion might be taken. Whether to hire an employee or not, majority's opinion might be taken. But if you want to change the partnership business altogether, opinion of all the partners should be taken. Similarly, when the partnership is doing good, right, initially all the partners had put in their effort and everything, hard work, everything. Now when partnership has started growing, it's doing good, at that stage, if you want to add a new partner, right, like one partner might say that, okay, let's like include my friend also or my relative also. So whether other partners are agreeing with that or not, that also we need to take into consideration, right? Otherwise one partner might say that, okay, include all my family members. There we cannot go with majority opinion, but rather we would need consent of all the existing partners. If all the partners are agreeing that yes, we can admit this new partner, only in such a case that partner can be included, right? This simply you can remember if new partner is to be added, if entire partnership business is to be changed. In such cases, usually all the partners should agree to it. We cannot just go with majority's opinion. Next is right to retire. Every partner of a partnership firm has a right to withdraw from the business when the consent of with the consent of all the other partners. In case of a partnership is formed at will, this may be done by giving a notice to that effect to all the other partners. Usually in the agreement they will have this kind of a provision, right? Because simply they would not sit on a random day and start typing the agreement. It is done professionally. All these clauses would be usually there in the agreement. So if it is a partnership formed at will where they have not specified like a duration or a specific purpose during which partnership is existing, there usually they would mention the provision that might be you need to serve like 3 months notice and then you can retire from the partnership or some kind of a provision. So accordingly one partner can leave also if they want to get it done, right?
Mm-hmm.
Right not to be expelled. Every partner of a partnership firm has a right to continue in the business. A partner cannot be dismissed from the firm by any majority of the partners unless conferred by the partnership agreement and exercised in good favor and advantage of the partnership firm. That means simply because you are having some like conflict of opinion or something, you cannot just exclude one person from taking part in the business, or you cannot simply expel one person, right? You cannot simply say that, okay, fine, we are making good profit, let's exclude this partner so that we can earn even more profit. You cannot do like that. It would depend on what are the provisions that are mentioned with regard to expelling a partner from the partnership firm, right? Whether it is with regard to misconduct, misbehavior, what are the provisions mentioned, and accordingly it will be decided. Only if it is in good faith for advantage of the partnership firm, might be that partner had done something wrong, in such cases it might be done accordingly. So right not to be expelled, you cannot simply at your own wish expel a person. Right of outgoing partner to carry on a competing business. If you were into tourism, right, as a partnership, now you feel that might be you are not liking this partnership business, you want to start something of your own. There is no restriction as such, because in all these years working in tourism sector, you have gained some skills and expertise in that field, right? So you are not restricted from carrying on some similar competing business. You can open such kind of a business also, but you cannot use the name of that previous partnership, right? You cannot say that, okay, fine, this partner from this, like you cannot basically use the goodwill that people are having, right? You cannot make use of that thing, whatever they have established, but otherwise you are free to start any business. There is no restriction as such. You can start that, but you should not be taking benefit of that thing, right? Their name and their reputation. So it is right of outgoing partners to carry on a competing business. Once you are out from that partnership, you can go forward with any business. Right of outgoing partners to share subsequent profit. If a partner has passed away or he has ceased to be a partner and the existing partners are still continuing with the partnership business with the property of the firm without any final settlement. Like one partner had also contributed his share and his might be some other stuff, right? And those things have not yet been settled. Simply this partner has gone out from the partnership. So until and unless all these accounts are settled, he will also be entitled to subsequent profit. Why? Because you are earning profit based on the contribution made by the person also, right? He might have contributed capital and other stuff. So unless and until it is settled, that person will be entitled to those benefits. If that person has died, that person's representatives would be entitled until and unless these are settled and everything is done properly, basically. Right? So right of outgoing partner, they would have two rights. They can open any business even if it's competing, and they would also be getting share on subsequent profits earned by the partnership unless and until accounts are settled between them, like amongst them. Right to dissolve the firm. A partner of a partnership firm has a right to dissolve the partnership with the consent of all the partners. Like I told you, if you want to change the business, include a new partner, or if you want to dissolve, that would be with consent of all the partners. Where the partnership is at will, the firm may be dissolved by any partner by giving a notice in writing to all the other partners regarding his intention with regard to how it would be dissolved, right? Basically, the provision also would be mentioned regarding dissolution of partnership, and based on that only, they can do it. So if there is an express provision mentioned with regard to it, accordingly, the person asks for dissolution of the partnership firm also. Right, so these are the rights which we have. Is this part clear?
Yeah.
Yes.
So we have to remember all of these. If they ask
Might be like 12 and also you can remember, because there can be one specific question on rights also, right? 12, if you remember, like you do not need to remember the inside thing, you would know it, right? Mostly it's in the agreement, whatever is provided, like that only. So if you can remember these things, right? Like sections also are complicated because sub clauses are there. If you are remembering, right, you would be able to explain, right? Like right to take part in conduct of business. Obviously, if you are a partner, you would be willing to take part. You would also want that your opinion is also taken. You would want to see their accounts, books, records, whatever is maintained. If you are putting your skills, your time, your effort, you would want remuneration also. If you have invested there, you would want share of profits also. If you have invested more amount of capital, might be you would be willing to get interest on your capital. With regard to advances, if you have made, other partners are not making, definitely you would want interest on that also. If you are doing something, putting your own money for benefit of the firm, you would want you to be indemnified. You would not want some other third person to just randomly enter the partnership. You would want that you are free to retire anytime. You should not be just expelled at any point of time if you are not doing anything wrong. Then if you are leaving the partnership, you can start any business. You would be entitled to subsequent profit unless and until accounts are settled, and you can ask for dissolution also. These are like normal things only, right? Common sense things only. If this part you can remember, explanation I'm sure you would be able to do, right?
Yes, yes.
Mhm.
So like 14 only, I think you should be aiming to remember. If one or two you forget also, that's fine. 12 you can at least write. Like if specifically there is a question with regard to rights, then also it would not be a problem in that case.
Yes, madam. Madam, one more thing, what I understood, that for every questions we have to write at least minimum 3 case laws. Okay.
See, the question again, the thing is that would you be able to remember the names also? Because if you are, like mismatching the names, that would be again a bad thing. So would you be able to remember that many cases if there are, take for example, one is general thing, mode of determining, then we have relation, duties, like 3 3 3. Would you be able to remember like 10-12 cases for one unit or not? That is a thing. If you can remember, we can discuss that. Otherwise, these are general cases which you can mention, even if it's like a with regard to right or something like that. So you can tell if you are willing to remember like 3 cases for one topic, I don't have any problem. But thing is that if you are investing your time, you should be able to write that also in exam. It should not happen that you just forgot the name of the case might be. So that is the thing. You can tell if you want to remember, I can just provide you that.
Or how about if we write one case law and then in second one we give an example? If person A does this, person B
Yeah,
like
like,
that,
like
would that have value?
what I feel is you can, like for each unit, right? You can remember some general cases that you can give in anything. When there is like an important topic, there you have got no option, you need to remember. Like that amendment thing, you don't have any other option. They are simply asking question like cases. But in these kind of things, when they are asking you about rights or obligations, it's not mandatory that you give that thing unless and until they are specifically mentioning that explain the rights and obligations with the help of decided cases, right? In that case, it's not mandatory. So if you remember some general one or two cases, that thing you can mention in might be your intro or when you are explaining your rights, anywhere you can fit in, and then you can explain the things. Might be that time if you are mentioning sections and all, that would be more relevant. Because see this question, right? Explain the rights and duties of partners in a partnership form. So here, if you are mentioning sections, that would be more relevant as compared to some cases because they have not specifically mentioned here. But if they are explaining, asking you that, okay, fine, what is with regard to might be determining existence of partnership, explain with the help of cases. There you cannot simply keep on repeating section 6, right? Because they have specifically mentioned what they are asking. So that is the thing. But then again, it ultimately depends on, like what are you planning to study and how are you planning. Based on that only, we should proceed.
What I feel, no, it's my thought. Anyway, we can reconsider it. It is not an issue. At least if we discuss about 2-3 case laws, even if we forgot to write the headings, at least we can mention the case law as per the decided case law, probably Supreme Court or High Court. So this is what has happened, and this was what decided. Okay, so probably the weightage to our weightage to our answer would be better than just only writing this. This is what I feel. You can think and you can guide us, not an issue.
Yeah.
Because when I was asking, since different people are having a different opinion, so I am just in discussion with many people, and just to have appropriate way to write and get only 32 marks, not more than that. Honestly.
See again, right? Like that is like just an like last option which you have, that in a decided case thing, right? That you should not be having in mind that, okay, fine, we have that option also. When you are
Yes.
writing it, right, you should properly only study. Like we can discuss three cases, whatever you are finding easy from those three, you can accordingly might be try to remember that. But this thing, right, that okay, fine, in a decided case, that would not be that much valid also, right? So you can try to accordingly focus on remembering the